Committee, I think we'll go ahead and get started. We have a full agenda today. First up, what I'd like to do is I'd like to turn our attention back to the highway naming bills we heard and hit probably just consent calendar stuff. Senate Bill 20. Adam, can you give us a briefing?
Sure, Mr. Chairman, 1 second. Thank you, Mr. Chairman. Senate Bill 20 designates a portion of United States Highway 69 as the Senator Dennis Wilson Memorial Highway. The portion of highway would consist of U.S. Highway 69 from the junction with I-435 South to the junction with 135th Street in Johnson County. And the Secretary of Transportation would place the signs once the cost requirements were fulfilled.
Committee, what's your pleasure on this bill? Are there any questions for Adam? Senator Clays.
Thank you, Mr. Chairman. I move the committee recommends Senate Bill 20 favorably, and the item being of a non-controversial nature, it be placed on the consent calendar.
Do we have a second? Seconded by Senator Hawk. Further discussion? All those in favor signify by saying aye. All those opposed? Motion carried. The bill is reported out favorably. Now turn our attention to Senate Bill 26. Adam, if you want to give us a briefing on the Bud Burke Memorial Highway.
Sure, thank you, Mr. Chairman. Senate Bill 26 would designate a portion of K7 Highway as the Senator Bud Burke Memorial Highway. This portion of highway would be on, of course, K7 from the junction with K10, then south to the junction with Santa Fe Street in Johnson County. And like was stated previously, the Secretary would install the signs once the cost requirements were fulfilled.
Any questions for Adam? Seeing none, committee, what's your pleasure on this bill? Senator Clays.
Thank you, Mr. Chairman. I move the committee recommend Senate Bill 26 favorably for passage, and the item being of a non-controversial nature, it be placed on the consent calendar.
Seconded by Senator Pittman. Further discussion? Seeing none. All those in favor signify by saying aye. Those opposed? Bill's on its way, reported favorably. Committee will now turn our attention to Senate Bill 100 concerning driver's licenses and restrictions. Adam, can you give us a briefing?
Thank you, Mr. Chairman. Senate Bill 100 would exclude the additional 90-day period for suspended license for certain individuals. The bill would remove a limitation from restricted driving privileges, and also the bill would remove and delay payments for fees that apply to individuals for the failure to comply with a traffic citation. In a little more specifics, Section 1 of the bill removes the additional 90-day period of suspension from a license for those individuals who have been found guilty of driving a vehicle while the license is suspended for failure to comply with a traffic citation. Section 2 of the bill removes the $25 non-refundable application fee for restricted driving privileges. The section further clarifies that the applicant will not qualify for restricted driving privileges unless there is no other basis for the license suspension or cancellation except for failure to pay fines or traffic citations. Additionally, the disqualifier from restricted driving privileges is removed for those individuals who have previously received a state suspension as a result of a driving while suspended conviction. Lastly, the bill would amend the $100 reinstatement fee for licenses. Currently, there is a $100 per offense fee, and this would be brought down to a $100 flat reinstatement fee. Would cover all fees, so it'd just be $100 reinstatement fee. And with that, I'd be happy to stand for any questions.
Any questions for Adam? Seeing none, we'll turn our attention to our first proponent, Senator Fauscudo. Welcome back to the committee.
Good morning, Mr. Chairman, committee members. Thank you so much for the opportunity to speak in favor of Senate Bill 100. Actually, Mr. Chairman, Senate Bill 100 each of you, except your new member here, and even your House members who are now Senate members, already voted on this bill. It passed out of the Senate in 2020, 39-2. And it moved on over to the House and was halted due to COVID-19. So we're back here again before you. You have my testimony, which is similar to last session, Mr. Chairman. I don't need to tell each of you how important it is to have motorists on the roads and highways driving legally with insurance. We want individuals to go to work. They need transportation to do that, especially with COVID now. A lot of them just can't afford to pay those fines. And so this bill sets it up where it's a win-win, to whereas they're making payments on their fines, having a restricted driver's license, driving back and forth to school, work, and other places, et cetera. So, Mr. Chairman, I also want to add that my number one reason for working on this bill years ago, when some piece of it is already current law, is that a young lady in my district who has a child with cancer, and she was driving her daughter to the emergency room one early morning and was stopped, and previously could not pay her car insurance. So she did not know that her driver's licenses had been suspended, and she was put in that revoked status where she had to wait 5 years to get her driver's licenses reinstated. And, you know, honestly, with a child with cancer, she's gonna, you know, drive her to the emergency room, you know, if she needs to. Mr. Chairman, this is a piece of legislation we've worked on a long, long time, and I would certainly urge the body to let it continue its process with the delay of COVID. So with that, Mr. Chairman, I know we have other people here. I will end and just urge your strong support for Senate Bill 100, and I'll answer any questions that the committee may have, Mr. Chairman.
Senator Pyle.
Thank you, Mr. Chairman. Senator, can you tell me what was the bill number in 2020?
I have it right here, Senator, and that was Senate Bill 275.
And this just seems to have some Judge Journey tracks on it. Is it any?
Excuse me?
Judge Journey, is this one of his former bills?
I'm glad you mentioned that, Senator, because that Senator Phil Journey, who is now a judge in Wichita, and he's in the traffic court there in Wichita. He and I worked on this legislation together, and there was a sunset put on it originally, and I introduced legislation to remove that sunset because we got reports from the Department of Revenue to whereas individuals were participating in the program. And so absolutely, that's why I say present on the Senate floor is in honor of Senator Phil Journey. Thank you.
Senator Pittman.
Appreciate you bringing this, Senator. I think this is an important bill. You know, looking through some of the testimony, it appears that a lot, if not a vast majority of driver's license suspensions are for not paying fines. And this does seem to be a workforce empowerment where people who are in poverty, correct me if I'm wrong, but who are in poverty, they need to get to work, right?
Oh, absolutely, Senator Pittman. Thank you for saying that. Most of individuals in this situation is just driving while suspended, and they're on their way to work or places of that nature. And I want to say thank you to you as well for when the bill made it over to the House in the Transportation Committee there. Your amendment on the bill, along with Representative Finney, has helped make the bill better. Thank you, Mr. Chairman.
Any further questions? Thank you, Senator.
Thank you, Mr. Chairman.
Next up, we have Ed Klump. Welcome back to the committee.
Thank you, Mr. Chairman. My name is Ed Klump. I'm here today in support of Senate Bill 100. on behalf of the Kansas Association of Chiefs of Police, Kansas Peace Officers Association, Kansas Sheriff's Association. As has been mentioned, this bill was Senate Bill 275 last year. We came in testifying in opposition to that bill initially. As a result of that, we worked with some of the proponents, Senator Braun, Senator Fauscudo. There were amendments made to that bill to address our concerns, and when it left the Senate, we were in support of that bill. We continue in support of the bill today, and I'd like to just review a few things about this bill that put us in that position. One, it's very important that we are able to hold traffic violators accountable for their actions. This means we need to get them to pay their fines, or at least what the court rules is the appropriate fine for them and for the violation. And this tool is one of the last remaining tools we have to collect that fine. The only other option is to send it to collections. When we send it to collections, collection attorneys win. The courts don't get nearly what they would get otherwise. And then we put a black mark on the person's credit rating, which not only affects them, it affects their entire family for years to come. And so we feel like this tool is a good tool to have. We want to keep it in place. That's very important to us. But we recognize there are changes that need to be made to this because it is creating some hardships that aren't necessary to achieve the goal that the provision has. I'd like to clarify one point we hear often in discussions on this. Sometimes we'll hear people talk about this being applied to parking tickets. It does not. If you look on the bill on page 3, starting on line 15, it describes where this applies. It applies only to traffic violations. It doesn't apply to other violations that were put on a citation, only to traffic violations, and it explicitly does not include parking, stopping, or standing violations. So just to clarify that point. We support the amendments on page 2, line 11 through 14, which removes the 90-day suspension extension for those people who are suspended only for the purpose of failure to pay or fail to pay fine. What that is there's a provision right above that, and you'll see in the bill, where if a person is convicted of driving while suspended, then when that suspension period ends or is scheduled to end, the division adds 90 days to that suspension because they clearly been driving while they were suspended. We think that this new provision is very good policy because it's not that these people were suspended because of their driving habits. They were suspended because of their habits of not coming in and taking care of their fine or not showing up in court. And those are two different things to us. And we don't think that 90-day extension, once a person's right on their fine, then why would we want to extend the suspension? So we think that's a very good thing. It is very important to us, though, that we maintain that 90-day suspension, as you see up on page 2, line 10, because those still apply to other suspensions like driving under the influence, reckless driving, habitual violator, and I think there's about 8 different serious violations like that. So we want to maintain that 90 days. And some of these proposals propose striking that 90-day entirely, which we oppose. So it's important that we retain that as this bill does. We also support striking subsection 4, starting on page, that's little Roman numeral 4, starting on page 4, lines 24 and 25. That is a provision when we were working with Senator Braun and Senator Fauscudo last year, we learned was a thing that the division was required to do that was another impediment to getting people back on track with their driver's license status once they were right with the court on this charge. And so we support striking that language. We also conceptually support the amendments on page 5, lines 21 to 31. This is where that charge for the $100 reinstatement fee currently is per charge, and it changes it to per case. It doesn't make sense to us that you charge a reinstatement fee multiple times for one reinstatement. I mean, that just doesn't even ring true. And we understand that there is a fiscal note to this. All of these fee things, some state agency is getting those fees. And in this one in particular, I'm sure you're going to hear how important it is that those fees be replaced before we make this change for the courts. None of the fee proposals in this bill touch law enforcement. We don't get any of these fees that come in on any of these things you're going to look at and consider today. And none of the other fee proposals are going to be in our radar to opine on. Those are issues you need to look at and what the effect of reducing those fees are. The one thing we would say is I think when you're looking at those, you should look at, should that fee, when it truly is to reimburse the state for costs, should that fee be removed for everybody or for those that have the inability to pay, that creates a hardship for them? So that's one thing I would ask you to look at when you look at that. We strongly support the idea of indigency and a person's inability to pay to be taken into consideration whenever the courts are collecting fines and fees. There's a difference between willingness to pay and inability to pay, and that needs to be recognized and dealt with accordingly. We continue to advocate for those that are under a payment plan with the court, continue to support that they have the ability to get the restricted driver's license as is in on page 3, line 36. There's some amendments to that, but that's already current law to allow that. Again, we're not opining on the elimination of the fee in that area. And I want you to know, we are not opposed to the idea of once a person is right with the court, and we consider right with the court, if they're on a payment plan and living up to that payment plan, they're doing what they were asked to do by the court, they're fulfilling their commitment, we have no problem with that suspension being lifted entirely. Now, I will tell you that that may cause hardships on the division. It may cause hardships on the courts, tracking those people going in and out of suspension. So you're going to hear about that. We are not opposed to that idea. So, Mr. Chairman, that kind of summarizes where we're at on this bill, why we support it, what's important to us that not change in the bill, and we appreciate the opportunity to speak to that today, and I'll stand for questions.
Any questions? Senator Clues.
Yes, Mr. Chairman, thank you. It was mentioned willingness and inability to pay. Obviously, that's subject to the courts. Do they do anything as far as for those who have a legitimate inability for community service to help pay that off? Are you aware of that or not?
Yes, I believe they do have that ability. The courts have a wide range of ability to hold people accountable. And they have the ability to look at indigency. They have the ability to really look at a person's ability to pay and set the fine within certain ranges. And so most of the courts work very closely to try to look at the individual case when they have that opportunity and to weigh that impact of what that fine is with their ability to pay, what their life situation is. That's very important. You know, a $100 fine to one person would be like us going down and buying a cup of coffee. To somebody else, it's a car payment. And so the courts are very good about taking those things into consideration. That's some better than others probably, but they have that ability.
Committee, further questions? Seeing none, thank you.
Thank you, Mr. Chairman.
Next up, we have Marilyn Harp, Kansas Legal Services. Welcome to the committee.
I am Marilyn Harp with Kansas Legal Services. We've been tracking driver's license restrictions on low-income people for a number of years. Tried to work in our spheres, both giving advice to people in that situation and also making a number of resources available on our website. But this is, as over the years, things have happened to support folks who do want to work, as Senator Pittman pointed out. I mean, we can talk about this as a driver's license bill. It's really an economic development bill. The one thing I would point out in my testimony is I did pick an incorrect number. There are about 213,000 driver's licenses that are suspended for unpaid fines. Currently, that is a huge number of driver's licenses that this bill can help support. because those people are multiple reinstatement fees away from getting it, even once they pay it off, they're 90 days away from getting their driver's license back. And this bill can solve some of those problems for your constituents. Thank you.
Many questions? Seeing none, thank you. Now turn our attention to Elizabeth Patton, Americans for Prosperity. Welcome to the committee.
Hi, how are you? Thank you, Chair, for allowing me to testify today. My name is Elizabeth Patton. I'm the State Director for Americans for Prosperity, Kansas. We have a lot of proponents today, so I'm going to keep my comments brief. You do have your written testimony in front of me. Just wanted to make a couple of points on here that a valid driver's license is a more accurate predictor of sustained employment than a GED or diploma, and then they are twice as more likely to stay employed. So part of our support for this bill, and actually some conceptual amendments that we think would do a lot to strengthen this bill, which we've been working on with coalition partners and proponents here to develop, ultimately making the point that providing a path for restitution similar to what other states have done actually demonstrates over time, especially in the Arizona case I referenced, that repayment is more likely. And while we do believe that people should make restitution for their debts, we feel like our current state incentives and the way it's currently structured is misplaced. And so we do believe that with some improvements, this bill and this concept does a lot to, as has been referenced before, help improve our economy here in Kansas long term, and as our mission statement is, allow all people to rise in our state. So we appreciate it. I'd be happy to stand for questions.
Many questions? Senator Pittman.
Thank you, Ms. Patton. Appreciate being on the same side of you on this issue. When you talk about improvements, what's the gist of the type of improvements you'd be looking to do?
Sure, and I think Mr. Klump referenced a few of those conceptual amendments, and some of my coalition partners are going to, I think, talk about that as well. But just some improvements that we've been talking about that just provides an opportunity to strengthen the bill. But I'll allow them to kind of go through all of that. I believe they're planning to do so. So I don't want to be redundant or take their time.
I hope so.
All right, thank you. Any other?
Other questions? See none.
Okay.
Next up, we have Deborah Barnes, Kansas League of Municipalities. Welcome back to the committee, Deborah.
Thank you, Chairman. I'm Deborah Barnes, Staff Attorney at the League of Kansas Municipalities. Our support narrows in on the point that the reviser talked about last. It's on page 5. It's the change to reinstatement fees. Instead of being for each charge, and as you've heard from Mr. Klump, there could be several charges involved. Instead of getting a reinstatement fee for each, there would be just one for each case. And that was one of the recommendations that was made by the Municipal Court Ad Hoc Committee a couple of years ago. And as you've heard, 213,000 Kansas drivers have suspended license. Well, rather not Kansans, probably, hopefully they're not driving, but 70% of those suspensions are due to the things that you've heard about, the lack of court appearance, not paying fines, or not being able to pay these multiple reinstatement fees. And the reason that the Municipal Court Committee came up with that is very much what you've heard from the other proponents, which is that there's a vicious cycle here that people get into. They can't pay their first debt, and then that goes on and on. And so the courts have found, the municipal courts have found, that increasing the burden of reinstatement with multiple fines has led to further violations rather than compliance. So we support that, and we don't have a position on the other changes. I stand for questions.
Committee questions for Deborah? Seeing none, thank you. Next up, we have WebEx proponent, Dr. Walt Chappell. Can you hear us, Walt?
Hello there, folks. Can you see me and hear me?
We can hear you.
Very good. Thank you very much, Mr. Chairman. We're very glad to have an opportunity to testify in support of this bill. It's one that a lot of people throughout the state have been working on since at least 2012. And as you know, it's come before your committee, and it's come before House as well as Judiciary. So it's extremely important that we get behind these reforms in this bill and make it possible for people to actually drive again legally on our streets. We, through the Racial Profiling Advisory Board in Wichita, have been working with this issue with people who are affected by this problem. And it's a situation, if you can imagine your own self, put yourself in their shoes. If you have not enough money to go down and pay your original fine, within 30 days, your license is suspended. If you didn't have a way to get to the court to appear before the judge at the time that they specified, then you have a warrant for your arrest. Now, either case, your license is suspended. And what that means is you're basically under house arrest. You can't drive anywhere in this state legally without a license. And so you're not supposed to move out of your home. You're supposed to stay right there until you come up with enough money to pay that original fine, let alone any additional fines that have been added. So this is a no-win situation. And it's been testified there are over 200,000 Kansans in this situation. And it's very important that we take care of a number of things, such as on page 2, it's talking about the 90 days removed. Once you've paid all your fines, there's no reason I can think of. I don't think anyone else in a reasonable mind would think, why would you hold a license back for another 90 days? If you've paid your fines, let's get on with it. Give folks their license back so they can get to work and take care of their kids, take care of their family. So that's on page 2, lines 11, 12, 13, and 14. Very important part of this bill. On page 3, we have an amendment that we have, I think, distributed to you folks to make it possible for folks who have a citation to pay to contact the clerk of the court and agree to a payment plan. This would allow them to make if you will, an appearance before the court without having to actually show up in front of a judge for a few minutes and show their face there. They are in fact able to plead their guilt or non-guilt on the phone and work out a payment plan with the court. This is something that's already done in a number of jurisdictions, but as we've talked to Judge Journey and the municipal judge here in Wichita, her name is Jennifer Jones, she's indicating it would be wonderful if we could get this to be a state law so that all judges across the state can make this possible for people to have a payment plan and also be able to do community service as part of their reimbursement. So they can comply. They don't have to have their license suspended. They can go ahead and make sure that they get taken care of their responsibilities. So our amendment on page 3, as you can see, Adam has put together some boxes for you to say, or enter a plea with the clerk of the court prior to the assigned court date, and if pleading guilty, then in accordance with the amount of the payment plan. These are all insertions that Adam has made to the bill that makes it much stronger and able to have a lot more people to comply. Now, we had anecdotal information that at least 80% of these suspensions are due to folks who have not actually appeared in court. They have now a warrant for their arrest, their license is suspended, but if we can take care of this one problem and allow them to be able to call in like they would with any other debt. If you have a doctor that you owe money to, if you have a car payment to make, you can call your bank, you can talk to people over the phone and work the arrangements. You shouldn't have to show up in their office, or in this case, in a courtroom, to try to work out those details. This amendment will allow them to take care of that. If you go to page 4, we're making sure on the top of page 4, you'll see line 2, it says no application fee will be required. This is for a restricted license. We're very strongly in support of the idea that Klump and others have mentioned, is that people need to comply with their license or with their citation. It's not an amendment to try to get people off the hook. It's saying, okay, you've got a responsibility now, take care of it. But if you've had your license suspended, this would allow you then to come back and get a restricted license and be able to drive on that restricted, to go to work, take care of your fines, and then come back later and be able to have it completed and have your license fully reinstated. So the application fee for a restricted license is extremely important. When you look at line 21 and 22 on page 4, that's extremely important that we take away the opportunity to say, all right, if you don't have a driving on suspended, or if you do have a driving on suspended, we're not going to give you a restricted license. This is a problem that we've had over the years of folks being able to apply. They'll pay their $25, but they never get a restricted license because they were stopped at some point driving on suspended. That catch-22 makes it almost impossible for people to ever comply. Now, we strongly support on page 5 the idea of if you are going to have a reinstatement after you've paid all your fines, it should be per case, not per charge. I think various conferees have already said that's extremely important and just an added burden on top of everything else. We find in talking with the folks over the years that the biggest problem they have is the accumulation of fines that have been added on. You know, there's additional fines every time they're stopped driving on suspended. And the third time, it's $1,500 and it's 90 days in jail. Now, if they're stopped 3 times in 5 years after driving on suspended, it becomes habitual. As a habitual violator, you don't get a license for 5 years, or excuse me, for 3 years. So we are in a situation where there's a no-win. They have no other way to get this taken care of except to try to find a time to get to work or get some way, take a side street or something, and avoid the police officers and hope that they don't get caught. But what we're trying to do is make sure that people can drive legally on a restricted license, work out a payment plan with the court, and have the opportunity for community service. And those ideas are listed on page, the next page where it says new section 3. New section 3 of the amendment takes care of a number of things that have really been roadblocks. One is that they are able to take care of their original fine through the monthly installment payments. And has been previously testified, there would be a uniform hardship waiver application. Many people don't know they can do this. So if that's posted on the website for the Department of Revenue and handed to them in the courts when they come to a court hearing, they will know up front, okay, I'm destitute, I'm really struggling here financially. I'd like to be able to comply with my citation, but how do I work that out? So that hardship application is something we want to make sure is available to anybody who can actually qualify for it and use it. Now, you'll see about a third of the way down that new section 3, it's talking about recall of warrants directly related to the suspension of the driver's license. Extremely important. Like I say, if you've got a warrant out for your arrest, many times people even come to court. They're afraid they're going to get arrested if they come. We've had amnesty programs here in Wichita, and we have to repeatedly tell people, okay, we're going to take that warrant away if you'll just show up. And many times people are still not trusting the courts enough to think, well, if I come, maybe they'll just put me in handcuffs. I won't be able to pay my fine. They'll put me in jail. So we need to give the judges the opportunity to remove those warrants. Secondly, we need to make sure that the judges are able to waive the reinstatement and collection fees that are due and related to the suspension. Now, that's something that the judges need to have already in statute. So when you pass this amendment, you're going to give them that flexibility and that discretion to use right there in their own case adjudication. Number 3 is talking about the expungement of previous driving on suspended. Now, that again is extremely important. If those cases are not expunged, the person is never going to get their license back, because we've had people who go ahead and pay their fines, and then they go to the driver's bureau and they say, can I have my license back? And they said, no, you were stopped driving on suspended, so you're not going to get it back. This allows the judge to expunge those previous convictions, so they in fact can pay their original fine, the one they had for not stopping at the stop sign or going above the speed limit, whatever the fine was for. But all these additional fines, they have an opportunity to get those expunged, particularly the ones driving on suspension, so the person actually can get their license back. Now, we're asking in this amendment on lines, section 4 of our amendment is talking about $15 for community service and $15 for attending classes. Classes will be having to do with safe driving, making sure our drivers are doing what they should do on the roads of Kansas and able to move forward with their ability to get their restricted license paid off and their regular license reinstated. Next line down is talking about the 90 days consecutive non-payment. If a person just, is neglectful of doing anything and get their payment plan taken care of, we want to hold them accountable, and you do too. So they have at least 90 days to get back into compliance. If they stop their payments, they have to get their act together and get in there and take care of that. Otherwise, the restricted license is taken back. So these are things, and Adams quickly pointed out the last page of our amendment, 8-2106, the traffic citation procedures. He's made sure that we include the opportunity to put the phone number and email address of the clerk of the court on the citation. So the person that gets a ticket while they're out driving around, they know exactly who to contact to take care of their responsibilities. If we just leave it out there in limbo, they don't know who to call, they don't know what number what to dial. And this makes sure that in statute, those tickets are going to have that information and a person can comply quickly. Too oftentimes people are just in limbo. They don't know who to contact, they don't know what to do about their ticket. And this makes sure that we clarify under that statute 2106 what kind of procedures they need to follow. And you'll see on the back page of that amendment, it's also talking again about the contacting of the clerk to work out the plea prior to the date. Now, as a caveat, I want to point out just one final thing in my testimony. We've talked to the folks in Wichita, for example, at the rescue mission on North Hillside. Some of you from Wichita know where I'm talking about. The Captain Doug Nolte was a former police officer and captain in the police department of Wichita. He's now the executive director. And he told me the other day, he said, well, 80% of the people in our folks that are living out here, they're all homeless. And 80% of them are here, don't have a driver's license. It's been suspended. They can't get to work. We have to drive them every place they go. If they have any appointed activities they're supposed to take care of, we have to drive them. So this is one of the consequences. Folks
Well,
get
we're going to have to
homeless,
wrap up
they're out
pretty
of their-
quick because we have other people testifying. So if you can get to a close quickly, that would be appreciated.
I'll be glad to, Senator. Thank you very much. My point is that when we put people under house arrest, they can't get to work, they can't take care of their responsibilities, and they certainly can't take care of their fines. So we ask you to pass this amendment as well as the 100 and make it so that all of these minor but major issues take care of themselves at one time. We don't need to leave loose ends. Thank you very much.
Any questions for Walt? I have one right off the bat. Walt, in your new section 3, that C, it says under the terms of original traffic fines or fines and court cost payments agreement made with the court, the municipal or judicial court shall order. That you wanted that to be a shall, correct? They have to order it if they've entered into the payment agreement?
Well, yes, if they're destitute, if they're hardship situation, the judge can make that decision and say, yes, you're going to have those fines reduced. We don't need to have all those additional fines added on. They never get out of debt. They never can pay off. And for Senate Bill 100 to work, the only way they can get the 90-day reduction on the end of the deal or the $100 per case is after they paid all their fines. The problem is people have thousands of dollars of fines that have been added on after the original infraction.
Thank you. Just wanted that clarification. Committee, further questions? Seeing none, thank you, Walt. Next up, we have Mike Fokker, Kansas Appleseed.
Thank you, Mr. Chairman. Can you hear me?
We can hear you barely.
Can you hear me better now?
Yes.
All right, thank you. Thank you, Mr. Chairman and members of the committee. I will keep my comments brief here, as I know there are still others yet to come behind me. My name is Mike Fonkert, and I am the Just Campaign Director for the Kansas Appleseed Center for Law and Justice, which is a nonprofit, nonpartisan organization dedicated to the belief that Kansans working together can build a state full of thriving, inclusive, and just communities. We support Senate Bill 100, and of course, as many other proponents here today have addressed, I think we have an opportunity to make this bill even stronger yet. As we've heard, over 134,000 Kansans have suspensions for unpaid fines and fees. Over 200,000 Kansans have suspended driver's licenses. The vast majority of these suspensions are not for driving behaviors, as Mr. Klump alluded to earlier, with 134,000 based on fines and fees. I know another large chunk is based on failure to appear. And so when we have a system that leaves over 200,000 working age Kansans in a position where they can't readily access employment, school, or other necessary life needs, we have a broken system. Over a dozen states across the United States have ended the practice of driver's license suspensions for unpaid fines and fees entirely. And we would love to see Kansas follow suit. We know that over 75% of people with suspended licenses still drive. That's the unfortunate reality, particularly in a state like Kansas. People have to drive. The American Association of Motor Vehicle Administrators states unequivocally that there is no empirical evidence that suspending someone's driver's license gains compliance in the way that we're aiming to gain compliance. We would like to see this practice ended entirely. But we know there are many, many voices that come into play here. And so what I would encourage the committee to do is to listen to the folks that are going to be speaking with you and have already spoken to you about strengthening this bill. At the very least, we must give these 134,000+ Kansans a pathway to get out from under the heaps of fines and fees that have been levied against them. All, again, not due to dangerous driving behavior. Driver's license suspensions truly should be reserved to keep dangerous drivers off the road. If we look at what's actually effective to get compliance, to get people to make their payments, we see that payment plans truly are the best way. You get money from a group of people that is unable to pay an entire fine or fee at once. And while we will undoubtedly hear about fiscal notes, what we won't ever hear calculated by anybody, because it's a bit abstract, is the economic value that we get from allowing over 134,000 Kansans a pathway to legally drive. The economic benefit of a change like that cannot be underestimated. And so I would encourage the committee to work with the advocates that come to them in the coming days and speak with them about this bill. There are a multitude of ways to improve this bill. And, the changes that are in Senate Bill 100 already are great. They're wonderful changes, but alone, they will not solve this problem. As we find ourselves in the midst of the pandemic with a new understanding of which of our fellow Kansans are truly essential workers, we need people to be able to get to work. We need to make a big bite at the apple here to make robust changes that will really help people. This is an economic bill. This will really help people that are struggling. And I would encourage you all to work to make this the strongest bill possible as it works through the process. With that, thank you so much for my time, and I will stand for questions at the appropriate time.
Any questions? Senator Pittman.
Mr. Chair, there's a lot of talk about payment plans and statements. I think Mr. Chappell had talked about that, and Mr. Funkert had talked about that. Just to clarify, my understanding is that's not in this bill. Is there a way we can have the reviser clarify that and see if, I just want to make sure that's not currently in the bill. It doesn't look like it is.
Adam?
That's correct. I believe a lot of the discussion is the proposed amendment, not actually the contents of the bill.
Any further questions? Seeing none, thank you. Committee, note you have 12 other proponent testimonies. We have 2 other written testimonies neutral, and we have on WebEx, we'll turn our attention to neutral opponents on WebEx, or neutral. Sean Jurgensen, Special Counsel to the Chief Justice.
Good morning, Chairman Peterson and members of the committee. Thank you for allowing me to appear today as a neutral conferee on Senate Bill 100. I'm Sean Jurgensen with the Kansas Judicial Branch, and my testimony today is not about the underlying policy on the bill, but the fiscal and administrative impact the changes in the bill, especially in Section 2, would have on judicial branch operations and our budget. And I ask for your help in addressing those issues as we move forward. Currently, when an individual fails to comply with a traffic citation and their driver's license is suspended, the court assesses a $100 reinstatement fee plus a $22 surcharge for each of the unpaid charges on the citation. This bill would do 3 things. First, it would strike the language on how the reinstatement fee is assessed prior to July 1. It would add language providing for the assessment of the fee on those citations issued on and after July 1. And it would alter the formula that assesses the reinstatement fee from a per charge to a per case basis, as Mr. Siebers highlighted at the beginning. And so my testimony today concerns how the judicial branch is funded by those fees once they're collected. The reinstatement fee is deposited into the state treasury, where the state treasurer credits the first $15 off the top of that $100 to the non-judicial salary adjustment fund, along with 41.17% of the balance. The $22 surcharge on each is credited to our docket fee fund. And those are 2 important funds for the judicial branch because we use that to pay our employees. In my written testimony, I cite our estimates so that you have those in writing, but what you'll see is that in FY 2019, just over $1.2 million in driver's license reinstatement fees were deposited into the non-judicial salary adjustment fund, and about $500,000 in surcharge was deposited into the docket fee fund for an approximate total of $1.7 million. And by changing the formula from a per charge to a per case basis, we estimate that revenue would decrease by approximately 44%. Which, based upon our FY19 numbers that we cite in our fiscal note and I've attached to my testimony, would equate to about $750,000 each fiscal year moving forward. So this loss in revenue would mean that there'd be less available for us to pay our employees with. And that's why I'm testifying neutrally today, and I want to bring this to your attention. Because if the bill passes and we are unable to replace that lost funding with a separate equal amount, it threatens our ability to compensate our employees and our ability to remain open. And the committee will recall at the end of January that the Chief Justice appeared before the Appropriations Committee and testified that our docket fee fund, which is as a fund pays for about 1/5 of the branch's bills, that it was already down approximately $4.7 million at the end of November 2020 because of decreased filings related to the COVID pandemic. And she's going to do that today, again, in our Ways and Means Budget Subcommittee. And also the Criminal Justice Reform Commission, when it was studying this issue over the interim, it recommended in its report that the legislature provide for substitute or alternate funding to offset these lost revenues. And so I respectfully request that you work with your colleagues on the budget committee to identify and allocate a separate equal amount of funding to replace the anticipated loss that we see with the bill as it's currently written. I also wanted to highlight a couple of procedural questions that could impact our expenditures and revenues. The bill strikes language that explains how reinstatement fees should be assessed for suspensions occurring prior to July 1 of this year. I don't know what legal effect that would have, but the two interpretations that first come to mind, one possibly being whether the fee can remain assessed at all, they would both carry substantial funding loss and significant administrative complications for the court system and for Kansas. And if that interpretation applies to all cases that are currently on file, the fiscal effect would likely be even greater than I was able to list in my testimony. And I also wanted to remind the committee that the judicial branch, we contract with debt collection agents on behalf of the state to assist in collecting these fees. And as written, this bill could impact those fees that have already been assessed and are in collections. And it could subject the issue to reexamination by a district court for a determination of what can remain in collections and be collected. And so this would take a considerable amount of time, including possibly recalling certain cases from collections. And so to help avoid some of these logical issues or these logical issues that I've highlighted, we've attached an amendment to my testimony, and I would ask that the committee favorably consider this amendment so that it would cause the changes that you're contemplating in the bill to operate prospectively starting July 1, 2021. And these amendments that I've attached would also clarify that those suspensions that were imposed prior to July 1, 2021 would be handled according to the law in place at the time the suspension occurred. And so those amendments would help on those logistical issues that I highlighted at the end, but it would not fix the lost reinstatement fee and surcharge revenue of approximately $750,000 that we anticipate. But Mr. Chair, thank you again for allowing me to testify, and I'd be happy to answer any questions the committee has.
Any questions? Senator Pittman.
Thank you, Mr. Chair, and thank you, Mr. Jurgensen. Appreciate the perspective. You know, I'm not one who feels we should pay for the judiciary out on the backs of the working poor who are caught in this cycle. I don't think you are either, but that's the way it's come to us now. And I do support, obviously, paying for judiciary salaries, and you know, we are one of the lower paid judiciary branches in the United States. But this seems like a punitive way to do it. So I understand your point. You don't collect all this money, though, right? I mean, these are people who can't pay their fines often, so this is revenue that should be there, but that's often not there, correct?
I don't know the rate on collection. And I want to make sure, I want to say this again, because I do worry that my neutral testimony is going to come across as opponent testimony, and that couldn't be further from the truth. I'm not testifying on whether or not this is a good or a bad idea. Instead, I just want to highlight that there are administrative issues that accompany changing the policy. And should the bill go forward, we're just simply asking that our colleagues in the legislature find an equal and separate amount of funding to replace the lost reinstatement and surcharge fees that we're anticipating. I don't know the rate on collection return. I will highlight, though, a couple of years ago, we were able to codify language in this statute. You can find it at subsection E that allows a judge currently to modify or waive assessment of the reinstatement fee upon a demonstration of manifest hardship. And so we know that judges are considering those issues in the field.
Any further questions? Senator Cluse.
I wonder if we can get that rate. It'd be good to know that information.
Can you repeat the question?
It would be good to get that rate to know that information.
Don, do you think I could provide that for the committee?
I can see what I can do. I don't know if that's something that we track in the system, but I will see what I can find.
Thank you. Committee, further questions? Seeing none, we are adjourned.
Thank you.